What is going on, guys? Welcome back to the channel, to the Butterfly Monkey channel. Today will be a continuation on American Jurisprudence Business Trust, Volume 13. And this is going to be, Section 6, right? Liability of Trust Estate and Availability of Trust Property to Creditors. Right? This is going to be a very short video. The next video on this will be on regulation, which is very long. So that's why this is going to be short. I chose not to combine them. Otherwise, it would have been an hour and a half worth of video. So to continue, this is subsection 74 generally. In the absence of statute or a provision to the contrary in the contract or in the trust instrument. So that's two things. In your contract that you're doing with other people or other persons, or in the trust instrument itself. The property of the business trust cannot be subjected to the claims of persons dealing with the trustees by the ordinary writs and processes in an action at law. Under these circumstances, the courts have refused to hold the trust estate liable by implication because of benefits received by it under a contract between a trustee and a third person. And where the trustees are personally liable for a debt, it has been held that the trust property cannot be reached by execution or attachment so as to prefer the creditors over the creditors in settlement of a trust. Under some circumstances, however, creditors of the trust may resort to equity to reach trust property. So I'm going to read these annotations because I think it's kind of important. So the first one is, in the absence of a stipulation to that effect, the trust estate is not bound by or liable on a contract entered into by the trustees for the benefit of the estate, and a trustee cannot charge the trust estate even by his contract without express authority in the trust instrument. In this Illinois case. But where all the legal and equitable interests are merged in the trustee so that the trust becomes a mere form, the property has been held to be subject to the claim of an individual creditor of the trustee. Now, individual creditor, that means that the trustee has what? He's probably benefiting. In some way, somehow, he's benefiting or something that it makes him liable. There's no other way around that. There's liable. Outside of reading this case right here, to understanding the context of how he was being held, odds are it was because he had some power that he should not have. And the other ones are just additional to read. The trustees acting within their authority may, by contract, express or implied, create a lien on trust property to secure the performance of a contract entered into in behalf of the trust, and such lien will be enforced. Also, the trust estate has been held to be liable for the torts of its employees and for torts committed by the trustees in carrying on the business of the trust, where the trust estate received part of the fruits of the wrongful acts. The trust estate cannot ordinarily be directly reached by a creditor of an individual shareholder. The interest of a shareholder being personality and not real. This is just personal property. That's what they're saying here. And not real estate. The levy of an execution on real estate, title to which is held by the trustees on a judgment against the shareholder individually, creates no lien on the trust property. And that's because the beneficiary, the shareholders, all they are is holding a piece of paper that says that they will receive income. That's it. They don't have no rights in the property. They don't have no rights to do anything with the property or anything. They only have the right to receive income if and when it's declared and at the end of the trust, at the termination. Footnotes go all the way to 15. Action for wrongful death against the trustees sued as trustees, trading as John Lucas and Co., under a trust agreement exempting the trustees from personal liabilities on account of the negligence or misconduct of the agents or employees of the trust. So this is an action for wrongful death. It didn't say anything. It just said sued as trustees. Number 14, a business trust engaged in operating oil wells and developing oil properties is liable in an action based on the acts of its trustees in removing oil from adjoining properties. So they're stealing. There's another case. This is a video. I don't want to say it's the men who built America, but it's something like that, where they couldn't get a lease for a specific property to get access to the oil. So they got a lease to the adjoining property and built some device that would go on a steep angle to access the oil. And, the other owner found out, and, the oil company on the bluesing for violating something. I remember that part, but I forgot the exact circumstances. Where the company had the attributes of a business trust, but was treated as a partnership in the nature of a joint stock company. So, subsection 75, effect of stipulations regarding liability. The right of persons dealing with a business trust to resort to the property of the trust estate for satisfaction of their claims may depend upon stipulations for liability of the trust estate, or against the personal liability of trustees or beneficiaries expressed in the trust instrument or in the contract between the trustees and such third person, where the trust instrument exempts the trustees from personal liability and provides that persons having claims against the trust shall look to the trust estate for payment. It has been held that such persons are entitled to proceed in equity to recover therefore out of the trust estate. However, a trust instrument provision requiring the trustees in every written contract to stipulate against the personal liability of trustees and beneficiaries and to give notice of their capacity as trustees has been held not to render the trust estate liable on the implied contract for benefits received by it from the contract between the trustee and the third person. And the footnotes, they tell you go to Legal Forms, Volume 3, which is common. I don't recall this. Is an Illinois case. I don't recall this one. I don't recognize the name. Number 20, Supra. So they quoted the case above this case right here, wherein the court said that instead of creating a lien on the trust property, such a provision merely gives direction to any execution which might be issued on a judgment against the trust or its members. And that's what it is. It's a direction to anyone who's contracting with you, with the trust, to look towards the trust estate for any, torts or whatever, any injury, any grievances or whatever. Bonds issued by a Massachusetts trust, although payable to bearer, meaning anyone who holds it, have been held not to be negotiable instruments for the purpose of determining the title of one who procured them in good faith from a thief, where the bonds contained a provision that the trustee should not be personally liable thereon, or these things should be given. Section 76, trustees' right to indemnity or reimbursement as available to creditors. The principle governing trust generally, so this is a principle of just trust, right? That where a trustee becomes liable to a person in the course of the discharge of his duties, the satisfaction of the demand cannot be had against the trustee personally. The creditor may, by a proceeding in equity, be substituted to the position of the trustee and may subject the trust property to the satisfaction of his demand to the extent that the trustee would be entitled to exoneration, indemnity, or reimbursement from the trust estate. Applies with full force to Massachusetts or business trust. So this is specifically applies to them. But nonetheless, they're saying when the trustee is held liable, right, in the course of his duties, that a creditor may proceed in equity to subject the trust property for the satisfaction of the debt. But it's only to the extent, right, of what the trustee is liable for or indemnified for. Let's trust footnote 1. And they just give you the principle. So it's first edition on trust, subsection 348. Would have liked them to give more. In order that this principle may be invoked, however, it must be shown that the trustee has a right to indemnity or reimbursement out of the trust funds, and the trust estate can be reached under this doctrine only where an estate is indebted to the trustee or would be required to pay the trustee if he paid the claim, and the trustee is insolvent or a non-resident. And in order to enforce the payment of a note on this theory out of the estate to which the trustees could resort for indemnity, the plaintiff must show that the note was made by the trustees in the course of their duty as such. But where the personal liability of the trustee resulted from his violation of the declaration of trust in the manner of executing a contract, he was held to have no right to reimbursement out of the trust fund, and hence the persons to whom he became liable on reimbursement out of the trust fund, and hence liable on the contract, were held to have no right to reach the trust fund on the theory of being substituted to the rights of the trustee, notwithstanding the facts that the trustee received no benefit from his wrong, and that the benefits from the transaction accrued to the trust. So footnote number 2, where a trustee has honestly incurred personal liability within the scope and for the benefit of his trust, creditors for such liability may reach the trust property by being substituted for the trustee and standing in his place to the extent that the trustee is entitled to be indemnified. And that's what it is. It's the creditor, he's taking over the position just to get paid. But the thing is, in that case, right, where the court makes that determination, right, dude, he's only, he has to follow the trust document too. There is no doing whatever you want in this case. He is bound by that contract also. And the only thing, like it showed up here, the only thing he's eligible to receive or gain access to is what the trustee would have received in reimbursement or indemnification. And that's it. That's how short this one. It was short and sweet. The next section is going to be regulation. So this is going to be big. This is going to be all the blue sky laws and so forth like that for businesses. So hopefully you guys will be for the next one. And I guess that's it. Yeah. Until next time. Have a good one. And please subscribe and like the channel.